Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay, here we go. How is everybody? Boy, do I have a fun show for you today. It's always fun when the defense is about to get their butt handed to them. Hopefully, maybe I'm a little too optimistic. Judge Cannoni has basically given the benefit of the doubt up to now. If you haven't been following the Karen Read case, the defense, after presenting in trial in their legal briefs, and I'm going to go over that, the ARCA witnesses as unbiased, unpaid witnesses, turns out they were collaborating with the defense and invoiced them. ARCA invoiced the defense for $23,925. Now, there's been talk that maybe Alan Jackson will get away with this in trial or in court by saying, well, they hadn't been paid yet. We were invoiced, but we hadn't paid them yet, so they weren't paid. I don't think so. I don't think that's going to work. They presented it to the jury. I played the clip before. They were really stressing that you've never seen me before. The Commonwealth could have used you as witnesses. You were paid by a whole other entity. Nothing to do. Your opinions are totally unbiased. And they helped orchestrate. Daniel Wolf, the ARCA expert, along with Rentschler. Well, Wolf was called out in this hearing for helping to orchestrate his testimony. So they did this with 3 witnesses, meaning the defense did this with 3 witnesses pre the first trial. So they'd say to the judge, look, we haven't complied with our discovery obligations because we can't. These 2 witnesses were hired by the feds, and there's still an ongoing federal investigation. We're not allowed to talk to them. But they talked to them anyway. People have been bringing that up, that they violated a federal investigation by talking to these witnesses. But they also did this with Marie Russell. They said, we just met her. We don't know what she's going to say, but we're going to put her on the stand anyway. So the remedy for this was not sanctions but voir dires, which was like great for the defense. No questions by the Commonwealth, few light questions. Send them on their way, and they don't have to give over their game plan to the Commonwealth. So in celebration, let's see, what should I do first? Okay, so let's go over their first filing. I just wanted you to get a little bit of the flavor of this filing. This is the filing that they the defense filed in opposition to the Commonwealth regarding the discovery before the hearing regarding the ARCA experts. And again, they hammer home the idea that these were non-biased, non-paid witnesses. This is from Julie Carpenter's Twitter or X. Now, okay, so this is defendant Karen Reed's opposition to Commonwealth's motion to exclude employees of ARCA. Okay. Now comes the defendant, Karen Reed, and respectfully requests that this honorable court deny the Commonwealth's motion to exclude the expert's testimony of employees of ARCA, namely Daniel Wolf, PhD, and Andrew Rentschler, PhD. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith. They're accusing the Commonwealth of not being in good faith, and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. LOL. LOL, neutral witnesses. Non-paid neutral witnesses. No bias whatsoever. The Commonwealth cites no legal authority whatsoever to support its extreme request to exclude these exculpatory witnesses. The Commonwealth falsely suggests that the defense has failed to comply with reciprocal discovery obligations under Mass R Criminal Code P14, but its motion is improper, unsubstantiated, and contradictory to binding legal rules and precedent in Massachusetts, and if granted, would constitute an egregious violation of Ms. Reed's state and federal constitutional right to present a defense. The Commonwealth alleges that the defense has failed or is unable to comply with its reciprocal discovery obligation, and that it's requested and has sought discovery from the defense and U.S. Attorney's Office pertaining to ARCA witnesses for about 10 months. But as Mass R Criminal P14 states, a defendant reciprocal discovery obligations do not begin until after the Commonwealth's delivery of all discovery required pursuant to subdivision or court order. Notably, the Commonwealth did not file its certificate of compliance until and hold on one second. I think the last hearing on February 6th. So they're saying they're doing it too. However, the certificate of compliance is meaningless because the Commonwealth has conceded that it still has additional mandatory discovery required under Rule 14 that it is not turned over to the defense. See, they're doing it too. They're doing it too, Your Honor. They're doing it too. The Commonwealth has failed to disclose the identity of an additional expert who worked on the reconstruction, has not turned over certain underlying data associated with its expert's reconstruction analysis, has not turned over metadata. There's their obsession with metadata again, associated with the Canton Police Department surveillance video, and continues to withhold additional communications between and among law enforcement officers and witnesses in this case. The Commonwealth, thus, is well aware that the defense's discovery obligations have not been triggered because the Commonwealth itself has not complied with its own discovery obligations. Ironically, listen to this part, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Well, we found out it was because they did hand it over. Moreover, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of the mandatory discovery obligations under Rule 14. Okay, I might have to take a break and let out my cat. But I will get back to this. Is this outrageous, guys? Is this outrageous? All right, I'm going to take a little break. I have a treat for you today. A song about Alan Jackson. I wrote it. So while I let the... Oh, no. My boyfriend just came in and saved me. I will play that a little later. We'll get to it. I have a song about Alan Jackson all ready to play. I was going to let my cat out, but shall we finish this up? I think so. This is outrageous. We can't, Your Honor. We can't do any of this. These guys aren't getting paid. The notion that the Commonwealth lacks sufficient information regarding the testimony of the ARCA experts in order to adequately prepare for trial is ridiculous. The Commonwealth has had 2 opportunities to cross the ARCA experts. First, at a voir dire hearing before the first trial. I went through that voir dire hearing, and he told the judge. My memory of it is he told the judge that he didn't want the Commonwealth to have 2 bites at the apple, and they couldn't cross them. And I remember it because he used the term "a bite at the apple," which always triggers me. It's a little like that and very unique. Those 2 phrases. The Commonwealth seeks to deny Ms. Reed's her most basic and fundamental right, the right to present a defense. So it goes on like that, but they go on that they're not paid, unbiased, and unreal, right? Unreal. I'm going to take a break. Here's the song I wrote about Alan Jackson. Please listen and enjoy. When we get back, I'm going to go through some of the memes, some of the reporting on the scandal, the fraud upon the court that the defense did, all after this. Don't go anywhere.
Criminal spout, legalese, lying by profession. When in doubt, blame the police. When my con gets exposed, I act deaf and dumb. Blame sudden onset amnesia. Got the press under my criminal spouts legally, lying by profession. When in doubt, blame the police. When my con gets exposed, I act deaf and dumb. Blame sudden onset amnesia. Got the press under my thumb. Drinks with my killer client at Smith and Walensky. Check paid for by fans. My elbow on the killer's knee.
Okay, there it is. Song written by me about Alan Jackson. I'm glad you love it, Jill. King of Kings. Thanks, Miss Lisa, and Tammie's digging it. Nice to see you, Tammie. Pats to Gizzy. Thank you, Dean Walker, for the super sticker. Nice to see you. Okay. So after this happened, should we go over what happened? We will get into the judge had to stop the entire hearing. So there could be grave consequences. There may be grave consequences for the defense, and be prepared to answer what the prosecution laid down, which was that these clients were paid, that this was all hidden by the Commonwealth. It was another Hank Brennan, really, that we saw in court. Extremely articulate. He's always articulate, but this was the wording he used. He meant business. He's not fooling around. He wasn't going to get pushed around by this criminal defense team who've been defrauding the court since the beginning. And now it's hard to keep up with all the illegal goings on in Karen Read, but now they have another raffle that you have to pay money to enter. And then you have to send your proof of the money that you donated to enter the raffle. I'm pretty sure that is a violation of raffle laws, at least in New York City. You have to have an option to enter without payment, which there seems to be none once again, but they got away with it. Also, there was a great catch on Twitter. Let me just pull it up. From the Alan Jackson Karen Read interview, where they talked about ARCA.
One of the things that the federal government did was hire this outside accident reconstruction team who would have no vested interest in the outcome of this case. How important was those two accident reconstructionists coming in saying, no way, no how?
I cannot describe the gravity of those two witnesses. First of all, they were unassailable in terms of their credibility and their credentials. There was nobody who testified that was more credentialed to talk about the issues that were attendant to them than those two gentlemen, those two doctors, PhDs. The fact that we didn't hire them.
Lie detector test determined that was a lie.
They can't be considered hired guns by the prosecution. The fact that the Commonwealth didn't even know their name. They were completely independent third parties who did not know Karen Read or this case, and they did not know that their assessment was attendant to Karen Read or this case.
Lie detector test determined that was a lie.
Central to their testimony, completely credible. I can't describe the gravity of those two witnesses and the impact that it had on the trial and getting to the truth. And what they said.
Right. So there they are, because this is the best thing that they had. All their other witnesses were, I called them garbage defense witnesses. You had Lucky Loughran, felt like they had drilled down his testimony, brainwashed him. Coerced him and whatever by threats of making him the next real killer, and gotten him on their side. And his testimony was absolutely unbelievable. And if you listen to the episode I did going through the interview with the juror, even the jury didn't believe Lucky Loughran. So the best thing they had were these ARCA experts. And this was the key refrain of Free Karen Read, was that these unbiased ARCA witnesses said that there was no way that John O'Keefe could have gotten his head injury from the car. It didn't look like a car crash.
Echoed everything that we had been learning during the course of our investigation on the defense side, which is that car was not damaged by hitting a human body. It did not hit a person.
Lie detector test determined that was a lie.
Right, because in Cross, they said they couldn't rule out a car crash.
And John O'Keefe was not injured by being hit by a vehicle.
Lie detector test determined that was a lie.
No way, no how. It didn't happen. As one of the witnesses testified, the physics don't lie. The science doesn't lie.
Right, that they doubled down. Science don't. Are you, Adam Lally, questioning me, a scientist? A PhD, total appeal to authority.
Car did not make contact with John O'Keefe.
Lie detector test determined that was a lie.
She didn't do this.
Lie detector test determined that was a lie.
Funny, right? It's clipped together. Funny way.
Karen, when the ARCA information came in, that document dump, I guess, what was your emotion kind of reading what they decided?
I didn't really know the details of it.
Lie detector test determined that was a lie.
Until trial, because I did not have the same access to those materials that the attorneys did because of the
lie detector test determined that was a lie.
Federal protective order. It was another moment, and there's been so many, that I realized, to put it mildly, how underhanded this prosecution is, that a district attorney...
How underhanded, as they're lying through their teeth, and did the most underhanded cons on the frauds upon the court. They're blaming the Commonwealth, they're blaming the police, and there's no one dirtier than the defense in this story.
Attorney can be privy to that accident reconstruction report and continue to pursue this case and not call Doctors Wolf and Rentschler.
Okay, so I guess that gives you an idea of that. Just a little bit of a fun video put together on ARCA. There's also been, let me see if I can pull it up, some memes, or at least one I'll show you on X that was done about the ARCA experts. There is ARCA invoice leaked, item description, a la carte testimony, one-sided evidence inspection, perjury, spousal, free Karen Reed cult membership. Because, of course, I think I have this in my bookmarks. The Daniel Wolf's wife, ARCA also took off their X account after this was exposed. Afterwards, there was also a bigger exploration done by Nebacracker. Let me pull this up on X. Here we go. Now that the numbers are crystal clear and we know no one spent $500,000 on ARCA, let's address the obvious. Wait, actually, let me go back to their earlier tweet. Hold on one second. I pulled it up too soon. Okay, here we go. Oh, so Karen Reed wants us to believe that the big, bad U.S. Attorney's Office swooped in like knights in shining armor because they're just so convinced of her innocence that the USAO, U.S. Attorney's Office, spent over $500,000 to disprove the Commonwealth's claim. How heartwarming. If only fairy tales were real. If the U.S. Attorney's Office truly believed Karen was the helpless victim of a corrupt cover-up, why did they only end up spending a whopping $9,071.31 on forensic testing to, quote, prove her innocence, unquote? Yes, that's right. Just over $9,000. Not even close to some of the numbers that have been floating around on the internet. The numbers don't lie. They are below. The answer is simple in the end. The U.S. Attorney's Office didn't need a forensic investigation. They needed the appearance of one. And this is often done in innocence fraud campaigns to make it look like they'll get certain people on their sides. They'll get an investigation that's just a really surface level investigation to make it look like something nefarious is going on. That was the narrative. Someone quickly realized that asking real questions would unravel the narrative, examining the vehicle, reviewing the Commonwealth's evidence, or analyzing data. Because essentially, what is fraud? Making something look like it's what it's really not. So to make it look like something nefarious is going on just by having an investigation. Or they'll say, so-and-so is under investigation. The judge is under investigation and gets cleared. They'll put the judge under investigation. This is not uncommon. Provided by the Commonwealth, they'll pull strings. Police officers under investigation. The police officer has been involved in so many other cases, meaning they have a pattern and practice of, say, arresting innocent people, quote unquote, or analyzing data provided by the Commonwealth to the defense would make it impossible to sustain the opinion they were being paid to produce. Any legitimate investigation would have exposed the inconvenient truth. The facts don't align with the story the defense was selling. The moment ARCA understood that further digging would force them to contradict the narrative, the decision was clear, so they stopped. They only spent $9,071.31, or just enough to keep up appearances. The remaining funds, don't spend another penny. The funds would be de-obligated and quietly swept aside. And in a convenient twist, ARCA turned around and requested an eerily similar amount as a direct retainer from the defense. In the end, ARCA didn't request any more data because doing so and doing it right would have exposed the truth. That Karen clipped John O'Keefe with her large SUV, smashed her taillight to smithereens, and did so purposefully, leaving him to die in the cold. That's me talking. Back to the tweet. This wasn't science. It couldn't have been because they didn't analyze anything. They weren't protecting the narrative. A narrative outlined, they were protecting the narrative, a narrative outlined by AJ and supported by a $23,000 retainer of ARCA for the defense. It's not for travel. It's not for time. Time paid to support the narrative. So here are the numbers. According to the federal PDS and USspending.gov, the Boston U.S. Attorney's Office awarded 18 contracts to ARCA between 2022 and 2024, totaling $15,000, $302.04, not exactly the $500,000 Karen breathlessly told the media was spent to vindicate her. Let's be crystal clear. She lied again. No one with an ounce of common sense would funnel $500,000 in taxpayer money into saving some self-proclaimed damsel in distress. Why would they? This isn't a Disney movie. It's a murder investigation. Now let's break down the contracts. Of the 18 contracts, only 6 were awarded during the time frame of Reed's indictment. You know, when she became the only person ever charged with John O'Keefe's death? All 6 contracts fall under PSC code R424, Expert Witness Services, and NAICS code 5541199. All other are legal services. Let's talk about dollar and dates. So here's the contract. October 2022, ceiling $35,700. Deobligated July 8th, 2023. Total spent $13,000 and $13,300. Why it doesn't fit, awarded long before ARCA claims they even started working. Here's another bill for $6,000. Why it doesn't fit, again, awarded before ARCA claims they lifted a finger. Another bills, no payment, no analysis, no proof of innocence. Okay, so here's the November 1st, 2023, ceiling $29,740.75. And then it was modified to a new ceiling of $33,740.75. Post mistrial, deobligated $24,669.44. Total spent $9,071.31. That's it. $9,071.31 for 2 PH level experts. Now, what did ARCA actually do for that money? Let's see. With evidence that was handpicked by the defense and provided directly to the U.S. Attorney's Office, that's correct. The defense provided items they wanted looking into without any inquiry into evidence in the Commonwealth's possession or control. That's correct. The Attorney's Office nor ARCA asked the Commonwealth for any data or evidence. ARCA conducted an so-called analysis Examine the vehicle? No. Conduct a visibility analysis? No. Review state police crash reports? No. Analyze text stream data, key cycles, speed, etc.? No. Confirm John's DNA on the taillight? No. Verify hair samples belong to John? No. Identify taillight fragments in John's clothing? No. Within the 9,000, all they did was give the opinion that was requested of them and build a cocktail glass cannon, something Alan Jackson and Daniel Wolf apparently thought was pretty awesome. There's one groundbreaking conclusion under oath, that the taillight couldn't have broken at 0 to 5 miles per hour. This rules out the possibility that she could have broken her taillight when allegedly lightly touching bumpers with the Traverse. And you read it right. 2 PhD experts, a murder trial, a good man dead, and $9,071.31 bought a toy cannon and half-baked opinion. So instead, they quietly bowed out, and the feds handed the defense their retainer request directly. Funny, isn't it? How the amount deobligated just happens to be quite similar to the sum ARCA requested for their private engagement with the defense. ARCA wasn't looking to disprove the Commonwealth's assertions. They were protecting the narrative. So true. ARCA wasn't working for justice. They were working for the defense. And now it couldn't be any more obvious. But so we may see Alan Jackson, we may see David Yannetti thrown off. And if Alan Jackson, that was Nebercracker on X, Bossy Texas chick. So they may be thrown off the case. Elizabeth Little would leave with Alan Jackson, I assume, because, I mean, let's not forget that David Yannetti was part of this, was in on all of this too. And they've all been lying to the courts. Right? I mean, let us not forget, let me go back to this and share this briefly. Alan Jackson's argument to Judge Cannoni. We can't talk to them, Your Honor. We can't do it. It's impossible. We're not allowed. So here we can
trial and reading the transcripts.
We've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
I understand that.
So this is sped up.
These experts were hired by the federal government, and they provided a report to us pursuant to the TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial.
So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here
that's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
See, I don't see that as being, the report, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Well,
I don't see that report. You can call the report detailed, but I didn't find it detailed. I always find that part of this video funny.
And you have not complied with your Rule 14 obligations.
We can't, Your Honor.
So you can't, but you haven't. So I am left with you haven't complied. So we need to get everybody here for voir dire. They can testify in voir dire, right?
Yes.
We need to do that well in advance of their testimony.
Okay, that's fine, Your Honor.
All right.
Yep.
And now tell me about this ER document.
Yes, sir.
Importantly, were you hired by the defense in this case?
No, sir.
Now tell me about this ER doctor. You've told me about 2 of the witnesses that you can't talk to, and this ER doctor. So I'm really questioning whether this, I talked to your friend John Lewin, who's also a friend of this show, Alan Jackson's friend. I used to work with John Lewin. I read something in the paper. This is Marie Russell's story. I got in touch with John Lewin, and John Lewin put me in touch with Alan Jackson. And we haven't had time to talk. Hiding her discovery. And the same remedy, voir dire for Marie Russell, which she failed miserably and was still allowed in. So people have been talking about why Judge Cannoni was shaking, why she basically had a meltdown and ended the hearing when they're pressed for time, causing possibly a delay in the trial. And if Alan Jackson and Yannetti get thrown off, we'll definitely see a big delay in the trial, as Karen Reed will have to find new defense attorneys, because I doubt she's going to want to go to trial with Robert Alessi, her pro bono, attention-seeking, clout-seeking lawyer. I mean, doesn't he come off, Robert Alessi, as the nerdy kid in the class trying to hang out with the cool kids? He's practicing rather boring law. He wants to be with the big-time TV defense attorneys. And it just appeared for a while that the cool kids were just using the nerdy kid for his homework. And he's putting out one fraudulent argument after the next and writing Marie Russell's, this is my opinion, writing Marie Russell's report. Hank Brennan noted the change in language and change in opinion from the first trial to the second trial, from what she testified to what was written in the report. Ditto Richard Green, when there were two reports handed in there. So here's, and here is, so.
We need to get everybody here for voir dire. They can testify in voir dire, right?
Yes.
We need to do that well in advance of their
Okay,
testimony.
that's fine, Your Honor.
All right.
Yep.
And now tell me about this ER docket.
Yes, sir.
Importantly,
So here's Alan Jackson questioning on direct the ARCA witnesses, Daniel Wolf.
you hired by the defense in this case.
No, sir.
Before this morning, you walked into court. You and I ever met face to face?
No, sir.
In terms of the commission that you were asked to undertake in this case, that have anything to do with the defense?
No, sir.
That have anything to do with the Commonwealth?
No, sir.
So a third-party agency hired you and commissioned you, or ARCA, with the responsibility of doing an accident reconstruction in this case, correct?
Correct.
Person to my left, this the female to my left sitting here. You ever seen her before?
Nope.
You know who she is?
Yes.
And whatever they are, those analysis, conclusions, and opinions in this case are completely independent of the defense and of the Commonwealth. Have I got that right?
It's based on the evidence. That's correct.
And you're not paid by either side here in this courtroom.
Correct.
Right. It goes without saying that you're certainly not being paid. It goes without saying, he says at one point. It's all so absurd. Hey, Tim, since Jackson disclosed the new info, don't you think he has set a time bomb trap that will embarrass the judge and prosecutor when it continues? I don't understand what you mean, Tim. The judge's fraud, the fraud that the judge let happen in her court, so the judge has been exposed for letting a fraud, as she turned a blind eye to all the fraud that they were handing over in their filings. She let it slip. She let this slip. So she's been exposed. And so has the defense. They had to hand over discovery. They had no choice. They were backed into a corner after 10 months of asking for it. They had no choice. And they know the judge. They know. I mean, the worst thing that could happen is Alan Jackson, I think, and David Yannetti could lose their law license. That's what I think should happen, but I doubt will. I don't think they should be ever allowed to practice law again. This is such a gross violation. We've just gotten used with these attorneys to all their fraud and lie upon the court. Let me know what you mean, Tim. I'm just not exactly sure. what you mean by a bomb. And it was really, and let's look at Hank Brennan in his whole demeanor. He came in like like a gangster meaning business. I know he's the mob lawyer, but he certainly came in meaning business in this hearing. So this is after Alan Jackson made a big stink about the metadata, and they haven't gotten this video didn't exist and the Sally port, and what a gross violation it is of Karen Reed's rights, those kind of things. Listen to Hank Brennan's answer.
Injustice brought upon the defense that half the facts are left out of the presentation. So to talk about reality.
Right. So then again, so curious again, he's saying half the facts have been left out of the presentation. Let's go back. This is how he starts. Like, he means business. He's not fooling around. He's not pussyfooting around. He's publicly calling out the prosecutors for the fraud that they've done.
It seems like another effort to portray some type of injustice brought upon the defense that half the facts are left out of the presentation. So to talk about reality, the reality is that I invited them to come download the DVR, NVR, where they full well knew that I had no idea if there was still video on there, and why would they be 3 years later? And after they filed a motion making representations that weren't accurate, I no longer had the confidence to have off-the-record agreements with the defense. There has to be a certain level of confidence.
So he's saying they're such liars that I can't have any off-the-record discussions with them because the defense are such liars and fraudsters, they're going to twist it. That's what he's saying. So he brought huge accusations to this hearing, and he brought the receipts. And everyone who knows a little bit about anything, the law, could follow what Hank Brennan was saying, knows that the defense and the judge have been exposed for the fraud. Now, I've heard people make this all about the federal investigation. Yes, everybody knows the federal investigation was done with Karen to please the Reed family, and it was improper. But that doesn't, in my mind, touch the fraud going on by these lawyers that has been perpetuated for years by these lawyers. Anybody want to remember the time that Yannetti told the court that Karen Reed had a brain tumor and a host of other ailments we've never heard anything about again? Or dreaming up ideas, defense, imaginative stories about what could have happened in an alternative universe to John O'Keefe, giving it to Aiden Carney, and then saying it's been reported as in their own legal filings. You can't do that.
That when you have an agreement and you try to help the other side, that the memory of the discussion is going to be portrayed accurately. And in losing confidence, the best way to practice for discovery is motion. And yet the court asked me to meet with the defense after court, and I'll always honor the court's request. So because of your order, we met with the defense. Now, as a matter of background, when they came out to look at the DVR, there was no motion. That was by invitation. It wasn't lip service. It wasn't trying to spin a story for the media. It was a good faith effort to accommodate the defense to an entitlement that they weren't actually entitled to. I didn't go on the 12th and speak to the police officers because we were here on Dr. Russell. I went after because I wanted to know more about the cameras. I had never visited the station. I wanted to know about the process. And I wanted to ask firsthand anybody that was there about the process because I wanted to do due diligence. And when I met with the chief and other officers, I was told by a retired sergeant who was there, DGM Petro, that he was the officer who would download video upon request. He never downloaded a 24-hour period. He was never asked to. There was never a motion to. When the government would ask, or state police would ask for a download of a particular event, like the Sally Port area, he would download it.
I mean, this is so absurd, too. What are they going to find in a 24-hour period? Your Honor, there was a squirrel that came into the Sally Port. Were they looking for a raccoon, a squirrel, and did the damage to the taillight? Are they going to blame it on an animal now? By the way, ID Discovery has a new trailer out. Looks like a free Karen Reed innocence fraud documentary, as they've done for so many other killers, like the West Memphis 3 child killers of Michael Moore, Christopher Byers. I mean, just unreal. They blamed it on and Stevie Branch. They blamed it on turtles and had Bob Ruff, who's just does basically his podcast should be called Innocence Fraud Weekly. I've been exposing Bob Ruff since I first started my podcast.
What he told me is that is on the DVR, an independent unit that has all the metadata and the logs if it still survives time. He said when he would download it, he then had his own hard drive at his office, and there was different files. One was called detective file because he's a detective. And he'd simply click and drag a copy of whatever he filed or copied for the government or the state police before. It wasn't a full accounting of all the metadata or all the video. It was whatever he decided to copy because he was asked to copy it. And so I thought, well, there's more information that exists. It's not going to be a 24-hour period. It's probably going to be cumulative, but I wouldn't know unless I looked. Now, the standard practice is the Commonwealth would then just ask the detective to download a copy, and we'd meet our Rule 14 obligations by providing it to the defense. It's as simple as that. The defense is entitled to know more. There's nothing mysterious about it. There's no hiding about it. There's no story. It's just video on the detective file on his hard drive.
But they want the metadata. They need the metadata somehow. They don't want the video, they want the metadata.
But I called
so they can prove that somehow it's been altered. That's where they're going, to conspiracy world. They're looking for something like metadata that most people don't understand, so that they can say it's been edited. This is why I say that when people say, well, there was no video of Karen Reed doing this. If there were a video, they would do exactly what was done with the Alan Jackson Karen Reed canoodling video. They would say it's edited, pieced together, faked. There's no amount of evidence that you could show a free Karen Reader to convince them that she's guilty. I mean, they should be walking away in droves after ARC has been exposed, but they're all still saying that the real scandal is that Hank Brennan misspoke in this hearing and corrected himself.
Defense, not only due diligence, professional courtesy to say, you are already involved in the process with the NVR DVR. I've already invited you to bring an expert. I want to download this information that he copied over time and give you a copy. And they said, we don't know how we feel about that. Can you wait? I did not want to wait. I don't want any video being overwritten or destroyed. It was against my judgment, but I was deferring to the defense request to wait. And now it has become part of the spirit of their argument of oppression that somehow there's something odd or miraculously hidden about this. It is simply video.
The spirit of their oppression. And you saw that in the filing I read in the beginning of this episode. The Commonwealth just wants to deny Karen Read the right to defend herself. It's not that we're hiding our that our experts are paid and biased and beholden to the defense and have picked sides, as Hank Brennan says in this hearing. It's that the Commonwealth is so mean and evil and wants an unfair trial for Karen Read and wants to just pull the defense right from under her. Right? I mean, that's really spirit of their oppression. Hank Brennan was on fire. I hope he comes in the same spirit Tuesday. I can't wait. It's like Christmas. I have a feeling I might be disappointed.
That the sergeant clicked and dragged to another file that we can go in, click and drag it to a hard drive, and give them a copy. After you asked us to speak in the back room, the 6 of us were there. We had a conversation. We said we would simply copy the video, and then as another measure, which was unnecessary, we'd actually videotape it. Now, we did that because the defense wanted us to, and also it seems if it's on videotape, it can limit baseless allegations later. So we were happy to do it. And then when we got back to the office, the request changed. Under the spirit of Brady violations and due process, it was suggested that we were supposed to engage now in a different process, and that was metadata. I don't even know if the detective file has metadata. I don't actually know exactly what they're looking for. It is a simple click and drag process. Whatever video exists with the sergeant, we will give them. We're obligated to give them. The only delay.
Doesn't it seem like they don't really want this video? Doesn't it feel like, just from this argument and when you hear Hank Brennan's side of the story, that if you're to believe Hank Brennan, it sounds like the point of what they're asking for is they hope this video was gone. And when it wasn't gone, they couldn't say that the police destroyed evidence. And now they're going to say that the police destroyed metadata because the video's still there. Doesn't that seem like what they're trying to do? Trying to make it look like the police are up to something nefarious or bad or wrong and hiding up an imaginary crime that they did, right? That came out of Karen Read and her team's head, that maybe they just damaged the taillight. But we saw the taillight that morning on the wellness check. It was smashed to smithereens, Karen Read, and not done by your love tap of John O'Keefe's car.
Them because they've asked for all these different accommodations and different styles of doing it. And so we want to meet our responsibility, download the videos, and simply give them to the defense. There's nothing else about this issue. It's that simple. And technically, we don't have any other obligation other than to download it. It seems as though when I extend courtesies and obligations, it becomes complicated. It's not a complicated process. So we'd like to finish our Rule 14, download the video, give it to the defense, and then they can make any commentary or argument they want about it.
Okay. End of the week. So there's just no making this defense team happy. And here's Hank Brennan's reply again to Alan Jackson, getting up in arms about it.
I think it's a very fundamental right. And I don't think the Commonwealth should dabble in taking a position trying to prevent an accused from having counsel of their choice. That being said, as Your Honor may be aware, Mr. Betterow is also...
So this is about Betterow, who is Aiden Turtleboy Carney's attorney, coming on board. And I would assume that he's already been helping Karen Read all along, but coming aboard as official lawyer for Karen Read.
An attorney for Mr. Kearney. And that is something that I think the court should consider and be thoughtful about for a couple of reasons. There is a history, a symbiotic relationship between Ms. Read and Mr. Kearney. There is a history of documented evidence showing the sharing of discovery between the parties. And inevitably, that discovery is promoted in such a way that abuses, harasses, and bullies witnesses in this case. Not unmindful that there's over a dozen indictments against Mr. Carney, which Mr. Bedrow is representing him for. Now, it's not great clarity, but it's been represented.
Do you see Aiden Carney sitting right there listening to this? Talking about a symbiotic relationship Hank Brennan is between Aiden Carney and Karen Reed. And it's been said they talk every day. First, they talk through an intermediary, Natalie Wawiki, and then they talk directly, and they talk over an encrypted app. Nothing to see there, right, guys?
That there is a relationship between Mr. Bedrow, Mr. Bradle, who's Mr. Carney's other attorney, and the defense attorneys in this case. There's a record that has been represented that the attorneys in Mr. Carney's case, Mr. Bedrow, Mr. Bradle, have an understanding with the defense attorneys in this case. That there's an ongoing, long-term, implicit mutual assistance and mutual defense that they've been a part of for a long time. Now, the Commonwealth is not entitled to any product of a mutual defense, but it is curious in that Ms. Reed and Mr. Carney are not co-defendants. It is curious that given the indictments, most of them that deal with witnesses in this case that allegedly have been harassed and intimidated, it is curious that that relationship exists and the nature of that relationship. It's not something that I think I'm entitled to, but the court certainly could delve into that ex parte. It's important because we'll later talk about, in a sanctions motion, a violation, a direct violation of protective orders in this case.
Right. So this is when they released Proctor's text message in a filing that was protected. And so they're asking for sanctions for that. So it's not just one going beyond the bounds of the rules of the court and the rules of the land, laws of the land. They haven't just blatantly, flagrantly lied to the court in terms of their ARCA witnesses. They've broken protective orders on evidence and released it. So, you know, Lally brought up fraud upon the court in one of his filings, but he was squashed down, up against it, dismissed, treated terribly, I think, by this judge. While she approved motion after fraudulent motion by the defense. I mean, it's like watching a mother with a favorite child. I mean, you couldn't not notice it between Lally and Laura McLaughlin for the Commonwealth, and the way that Judge Cannoni treated the defense team, and still does. So I think she should throw the book at them. But if that happens, you know, I'm of two minds. If that happens, if she throws Alan Jackson, Elizabeth Little, and possibly Yannetti off the team, then we have a year-long, I would say, 6 months to a year-long wait for trial, because everything has to be done all over again with a new defense team. And they have to give Karen Reed time to pick it, as she wants to hand over Ad Bedero. But I don't think other people suggested that they knew that this was coming down. I don't think so. I think that if they knew this was all coming down when they handed over discovery, that they would have had an answer. Like, Your Honor, this is being misrepresented. You don't understand, et cetera, et cetera. Instead, they all kept quiet, and Alan Jackson pretended like he didn't know what happened in court.
And the discovery in this case was provided to special attorney in Mr. Kearney's case to make sure that there was a thorough review of all discovery. And much of that was turned over subject to a protective order. And I expect there'll be a similar motion in Mr. Kearney's case. Within 24 hours of the violation in this case, there was a violation of different material in that case. And so inevitably, you have Attorney Betterow who will be serving two masters. He will receive protected information in this case that is supposed to remain protected and not leaked and distributed to the media and the press and court pleadings. And some of that information will not be information that Mr. Kearney is entitled to. And being in a position of representing two different defendants who are not co-defendants, being in that position is going.
Right, so Turtle Boy could get information on the witnesses, their phones, other things he's not entitled to that he may not, I would think he would already have from Karen Reed, but that he can, he could possibly use in direct cross-examination of witnesses in his witness harassment case. The judge should deny this. You're entitled to a lawyer, but you're not entitled to every lawyer. And this is the same judge who let Aiden Carney sit in court watching the testimony of these witnesses that he harassed. I think he was only barred from, one testimony.
Going to be a difficult task to manage, and I am worried, and I have good reason to be worried about the privacy of our protected material. I have good reason to be concerned about the improper dissemination of our material. I have a reason to be concerned about the continued harassment and bullying of witnesses. And this information, if a court order won't protect it, then nothing will. And so we know this relationship is substantive. We know it is a deep relationship. The attorneys, in fact, in this case, have direct communications or had with Mr. Kearney, over 29 calls each. And so, not to speculate, but...
So did you just hear that? 29 calls with Aiden Carney, the lawyers are making. And this is a good time to bring up, as they were publicly distancing themselves from Turtle Boy, they walk into court and David Yannetti is giving a butt tap to Aiden Carney. Like, good job. And Jennifer McCabe's lawyer is, while he's representing Reddington, while he's representing Jennifer McCabe, he's writing Aiden Turtle Boy Carney, I wish you were on my side, and great job. Like, great job harassing my client. Imagine if that's your lawyer. This is from Grant Smith Ellis's footage, but this is on my channel. So keep your eye on, here's Alan Jackson, Karen Reed, David Yannetti. Keep your eye on David Yannetti. He's right behind Alan Jackson. Did everybody see that? Happens really fast. So one more time. Whoop, I moved it. It goes too quick. Here we go. We'll try again. Did you guys see that? Right there. There's his arm reaching out. Good job, Aiden. Good job creating a environment of terror for my killer client. Okay.
Having a mutual agreement, a mutual aid agreement, does not allow an attorney then to become one of the attorneys who is entitled to protection under a protective order in a particular case. It doesn't. And that concerns the government. And so while I do not object to Attorney Betterow, they should have as many lawyers as they want. I think the court should have some caution and some concern and should consider some type of inquiry ex parte without the Commonwealth present about the nature of this joint aid agreement and the history of it and whether protected information was ever shared prior to Mr. Betterow presumably joining this case, and whether there's protocol in place, and if there is
Prior to him joining the case, he knows he's already part of the case. He knows he's already helping Karen read out
protected information in this case, that it does not leak again. It does not get shared with a non-co-defendant. I don't even know how to describe the relationship. I'm asking the court to consider assuring itself of those safety measures because this trial is going to happen. And these witnesses should be able to walk into this courtroom without fear, without bullying, without abuse. And that has not happened. For many reasons, it has not happened. And this makes it a more complicated issue. The defendant isn't.
Here he is calling out the judge again. You haven't done anything to stop this bullying of witnesses. Did you hear him? It hasn't happened. Witnesses are still being bullied and treated awfully. Judge should say NO to this.
Entitled to a fair trial, which means she's entitled to another attorney. So I don't object. But the Commonwealth is entitled to. The Commonwealth is entitled to a fair trial, and the witnesses are entitled to walk in this courtroom without being abused. Thank you.
Okay. Ms. Yannetti, I have to consider everything that was just said, but
I have to consider everything that was just said. So she was just called out there. So by the time, do you understand why she had a meltdown? By the time that it came for him to drop the bomb, she'd been already called out for her failure in this case. Failure to protect the witnesses. Failure to have order. Failure to maintain basically any kind of fairness for the Commonwealth. So, let me just continue on with Hank Brennan's awesome.
Things they didn't turn over that they expected to use for impeachment. They had to enforce it, Your Honor. Trial by ambush is simply that, trial by ambush.
Oh.
Saw this motion before it was filed, so I take responsibility for everything that's in there. But you know, we also make the point that with regard to you know, Trooper Proctor, it appears as though there was you know, he was monitoring the trial. At least that's the inference that we draw, because he specifically says the one part that he didn't want to watch was Mr. Jackson's closing argument, and he obviously uses derogatory language toward him as well.
Well, you know what? All this they released, they took a chance and released it for the fans, for the free Karen readers to rile them up. They know what keeps the money pouring in. Who did like Alan Jackson's closing on this side of the fence?
You know, if we turn over this information in advance, not only does the Commonwealth get a chance to blunt this information by having the witness be given an opportunity to mold their testimony to take into account the impeachment information, but you know, this is a I won't say unique trial, but it's a rare trial that, you know, is streamed online. There's obviously a lot of press interest. Some people are watching everything that goes on. The court has issued sequestration orders. We don't know for sure whether they've been complied.
So doesn't that mean you should comply, even be more on top of what you put out into the public domain? They knew what they were doing when they put out this protected text of Proctor's post-trial.
With, and to the extent that we turn over this impeachment material and the Commonwealth uses it, it's another opportunity for a witness to see potentially in advance something that could otherwise be damaging toward cross-examination. So switching to the Commonwealth.
Oh, so they're saying we've given we've actually helped Proctor because we've given him a heads up. Like the Commonwealth. Give me a break. He knows what his text messages are.
Motion for sanctions. Understood.
All right, so, Mr. Brennan?
I mean, he's just read them to filth already. And we haven't even gotten to the big one.
The court shouldn't force reciprocal discovery. You shouldn't force it, Your Honor. Trial by ambush is simply that, trial by ambush. There were many instances when I reviewed this trial where the defense came up to sidebar, they had pictures, photos, things they didn't turn over that they expected to use for impeachment. And the rule requires them to do that. The reporter's note to Rule 14 talks about reciprocal discovery. Quote, even-handed discovery to both sides will improve both the administration and the delivery of justice. A witness has a right to look at information before their testimony. Just like the Commonwealth provides all evidence to the defense should do the same. Now, it's notable in the rules, although they're changing March 1st. We look at Rule 14A1A. That has a limitation in discovery for the Commonwealth under the person's direction and control. The reason for that is because the Commonwealth, unlike the defense, must provide all discovery in their possession and control. So, for example, if the Commonwealth is going to call an expert, they have to provide everything. Although the rules are a little bit more limited, it is the best practice to provide everything. If the Commonwealth is not going to call a witness, they still have obligations. And that is why that language is in Rule 14A1A. If the Commonwealth seeks consult with somebody, they're not going to call, they need to produce it to the defense. For example, I get random emails from unknown people, anonymous.
Right. So I hand over my random emails from strangers to the defense. Anything regarding this case, I'm handing over. But look at Karen Reed. With her eyebrows done, her hair done perfectly, makeup always in a new outfit. Anyone else doubt she's $5 million in debt?
Sometimes there are names on them talking about theories of the case. I give it to the defense. Because it's in my possession, custody, or control. I have no intention of calling an anonymous person, but because I have the information, because I am the Commonwealth, they're entitled to it. If we look under 14B, it's different for the defense. If they're going to call a witness, they have an obligation to produce evidence. If they have evidence they're going to use at trial, they have an obligation to provide it. And so allowing the defense to simply hide information because they think it's impeachment at trial is uneven-handed. It's not fair play. It's not in the interest of justice. There is no caveat or exception to the defense that they're entitled in state court anyways. Federal rules are very different. And
federal rules are very different. Invincible says since the feds are not coming, her cult is doomed. I don't know. They all seem to be saying, well, this is normal. Right? Aiden Carney sort of passed the buck and said, well, this is normal to pay a witness. That's not the point. The point is they lied. They presented a witness as non-biased. Reminder, it doesn't matter who emailed who or how much was paid to house and lodge a witness. There is nothing but a distraction from the fact that two doctors said, yeah, but they were biased. It does matter. Their bias matters. That's why one of the first questions in cross that expert witnesses are asked is, how much were you paid? Jurors are entitled to know any element that's connected to bias, how much they were paid, anything that would possibly bias or change their testimony. And not only was it changed, it was crafted, scripted by the defense.
In state court for them to withhold reciprocal discovery. The order of the court at the first trial, even though it wasn't followed religiously, was that reciprocal discovery was an obligation of both sides. And that should not change. It's going to create chaos. It's going to create delay in the case, and it's going to create an unfairness. It will be trial by ambush. It will be. And so since there is no caveat or exception for the defense, and since there's no entitlement to withhold impeachment material, we should not make an exception for this team. They should provide it like everybody else. So I'm asking you to maintain the reciprocal discovery order that is already in place, and then hopefully at this trial, it'll be abided by.
Okay. Was there any follow-up to that? The motion for sanctions will be a little bit later.
Right. He's saying, not only am I expecting discovery, but we're not doing what we did last trial with these voir dires. We haven't met these people. We're going to have another voir dire. Okay, let's skip past Elizabeth Little. And this is, so she brings in another case.
There's no objection. We'd ask that that be allowed.
Oh, her voice grates on me.
Thank you.
Anyone else?
All right. Mr. Brennan.
It's important to represent facts accurately. And the court has ordered in the past, when representations have been made, that they be accurate. We hear an echoing of a claim of Brady, but we hear no substance behind that claim from the defense as to, number one, Commonwealth is not going to make logs up that don't exist. They're not going to make a record of something that is not in writing, that there is no witness for. The defense has asked the chain of custody, logs, evidence, reports. If they existed, they would get them. I told the defense in an informal discovery request I would look into any chain of custody information, and I did. I've spoken to a number of witnesses, including the retired sergeant, and I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded them, who touched them, and who they went to. But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot invent a chain of custody that is not in writing and there is no witness to. I've done my best to be thorough and diligent, and they will receive a report and have all the information that we have. It's odd that it's important during argument to mention that there's an ongoing federal investigation and then list a number of witnesses for the Commonwealth, implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto. And so they just throw out terms and words for our audience that's here on our right to try to create an illusion of impropriety. There is nothing that they have provided about the Birchmore case that will provide a basis for the Commonwealth.
For the audience that's here on our right, so he's talking about the media, what the media picks up on. And it is shocking, the media stories on this. I tell you, every lawyer that every lawyer gets how bad this is for the defense. I told you before, I heard from David McKenzie sending me, who was the criminal lawyer, We just talked about the Karen Reed case. If you want to go back to that episode, it's called How to Defend Your Client in Court, not the Court of Public Opinion, something like that. And he sent me the article about what happened at this hearing. And essentially, it's like they got them dead to rights. Their hands caught. Everyone gets it. But the media is running with like, well, maybe Alan Jackson has a reason for this. Really? That reason he wouldn't stand up and scream about in court? We've seen Alan Jackson when he feels hard done by the court. He stands up in tantrums like a child.
To then now go scramble and search for information that there's no good faith actually exists. It's easy to throw out a name and attach it to the Birchmore case, troopers, the DA, malign their name the way they know how to do. But when you're arguing a discovery motion, there must be a factual basis for it, a factual basis, a good faith basis. We hear the defense say that Trooper Guarino says, nothing to see here. I have not seen that report where Trooper Guarino says nothing to see here.
They're just making up dialogue for Trooper Guarino. Nothing to see here. Funny bunny. Little knows the truth, meaning Elizabeth Little knows the truth. That's why she trembles. She doesn't. She has such a... It's a hard voice. Her voice is difficult for me to listen to. She's bringing the Sandra Birchmore case. So essentially, he's dismantling here the innocence fraud campaign of Karen Reed, one by one. For those that have ears to listen, he's telling you how it's done. Get an investigation going. Hint at some kind of impropriety. The evidence is there. Don't wait for the explanation like it's 3 years later. It was there. Now it's the metadata that's important. Oh, it is there? See, they're destroying evidence. Oh, they're not destroying evidence. What about the metadata? Is that still there? I don't even think they want that footage. It's just to keep their innocence fraud campaign, pre-trial innocence fraud campaign, which makes this so dangerous and unusual, going.
I don't know what report they're speaking about when they suggest Trooper Guarino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Miss Reed's case. They just say it. And so you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience. And so the reality is the Birchmore case is being investigated by federal authorities. There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case. Ms. Birchmore was a victim.
Right.
No.
So they're just going to try to marry the Karen Reed case with the Sandra Birchmore case. And, you know, which is interesting because, boy, of all these people talking about, don't, you know, the free Karen Reed cry before last trial was, you know, innocent and proven guilty, which is the standard for jurists, not the standard for the public. But, you know, we can have any opinion we want pre-trial. We're not deciding her fate. But now that with the Sandra Birchmore case, they've totally already convicted a guy way before the trial.
Number 4, unredacted copy of all reports, communication, handwritten law enforcement notes.
So my point is, when it's easy for them, when they want to convict someone in the court of public opinion, or Jennifer McCabe or anyone else, any of the other witnesses, that they've played eeny, meeny, miny, mo. Who's the real killer? It's anyone but, the answer to that is anyone but Karen Reed.
Again, in the Birchmore case, why? Why that case? Troopers work on many cases. That case certainly has a public appeal to it because of the harshness of it, the sadness of it. But what does it have to do with this case? Nothing. But invoking it is helpful for the defense. So they do. You should reject it outright, Your Honor. Number 5, all communications, documents, reports, memorandum regarding Trooper Proctor administrative proceedings. Any information in the Commonwealth's possession and control, we would and we do turn over. In addition to what's in our possession and control, we know that there's likely statements that would be helpful for the defense. So we have an affirmative obligation under Graham. In fact, I had a conversation with defense counsel, and they asked if I would join them in a phone call and speak to counsel for the state police to try to encourage the production of materials in this case, whether they're exculpatory or not, even material irrelevant. And I agreed I would do that upon request. Now, that call has not been set up by the defense, but when it is, if it is, I will be there and I'll advocate for them for this information. In addition, there's a Rule 17 that has been ordered by this court that imposes an ongoing duty separately upon the state police. Now, state police have certain protection where it's an internal affair investigation by law. I cannot usurp that law. I can only earnestly try to my best of my ability. I sent an email on January 28, 2025 to a number of attorneys at the state police. And I informed counsel in view of the Commonwealth's responsibilities under Brady v. Maryland in Giglio, and most recently set out in McFarland and Graham, the Norfolk District Attorney's Office is inquiring whether the Mass State Police Legal Department and law enforcement officers assigned to the State Police General Headquarters in possession of any relevant materials, statements of Mr. Michael Proctor, witness statements, and any findings relative to the department investigation and hearings relative to this matter. The Commonwealth is under a continuing duty to inquire and obtain all relevant evidence pertaining to witnesses in the matter of Commonwealth v. Karen Reed. All potentially exculpatory and relevant evidence must be disclosed to the defense. Exculpatory evidence is any evidence that would tend to exculpate the defendant or tend to diminish credibility. Exculpatory evidence also includes any allegations of misconduct that bear upon the truthfulness and the integrity of the investigation or could be read as suggesting bias or would question one's credibility to be impartial. In addition to any obligations under Mass Rule 14, Commonwealth alerts Internal Affairs Division of Massachusetts State Police to an ongoing Mass Rule Criminal Procedure 17 order for the production of records regarding the investigation of Trooper Michael Proctor, to the extent that any records beyond that was initially produced in March 19, 2024. Please provide forthwith to the Commonwealth and the defense. So we are and have made best efforts to provide all of that material.
So they want to look at Michael Proctor's entire history with the police.
The defense is entitled to it. We cannot force them or compel them, but there is the Rule 17 motion, and we'll continue to abide by our obligation and duty. Number 6 and 7, we do not object. Number 8, there is a difference between ARCA, and we'll discuss that in more detail when we get to the ARCA motion, and expert discovery. We have provided, there is a difference between ARCA as an expert witness and typical expert witnesses. I can assure the court that we provided our entire case.
Wow, he's giving a hint of what's to come. Here's Elizabeth Little. What does that look mean? What do you think? There's a difference between ARCA witnesses. And other expert witnesses. And we're going to get to that. Hinting at the bomb that's to come.
Case file for our accident reconstruction expert. We provided all of our materials for all of our experts. The discussion between the experts, the oral discussion between the experts and me cannot be replicated. If there was anything inconsistent or exculpatory or helpful for the defense, I would reduce it to writing and I would provide it to them. They have all the materials our experts relied upon. They have all of the reports. They have all the raw data. They have the research material. I do not believe that tracking phone calls for a regular expert is possible, number one, and has any relevance whatsoever. It is different for ARCA, and again, I'll delve into that when we talk about ARCA because that is a very unique situation. We have been very broad in our expert disclosures. Written communications, number 9, email, text message.
Oh, not you too, Hank Brennan. Oh, triggering me. Unique means one of a kind. Something cannot be very unique. It drives me crazy. It's the most misused word, the English language.
Between Norfolk County DA's office, law enforcement, and any
or misused phrase, I guess.
Expert. Again, there's scheduling issues. I've been through emails and text messages, and I have given a healthy production of materials that are relevant, would even suggest any type of bias. And in addition, I've asked for a production of any statements whatsoever with any witnesses in this case so that I can review them. And I've received production from 2 troopers in this case that I have to review. I received them at the end of last week, and I'll continually look through all correspondence available to me for Rule 14 materials and provide it.
All right. Any follow-up, Ms. Little?
Okay, let's skip past it.
Obligations for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024.
Okay, so here's the bomb. Should we take a little break? I think so. When we come back, I think I'm going to play for those that missed it, came in late, I'm going to play my Alan Jackson song, take a little break. I think we need a little palate cleanse before the big reveal, the big bomb dropped in court by Hank Brennan. I'll be back in 2 minutes. Don't go anywhere. Here's my song I wrote for Alan Jackson, music by AI, lyrics by me. Take a listen.
Criminal spout, legalese, lying by profession. When in doubt, blame the police. When my con gets exposed, I act deaf and dumb. Blame sudden onset amnesia. Got the press under my thumb. Drinks with my killer client at Smith and Walensky. Check paid for by fans, my elbow on the killer's knee. I'm a lawyer, a criminal lawyer. Think like a criminal spout.
Okay. Is everybody ready for the big bomb? Big bomb coming by Hank Brennan. Drop the bomb on you. That's right. Did anybody remember follow the Adelson case? But you did. You dropped the bomb on it. Wendy Adelson's cross, didn't you? Hank Brennan's ready to drop the bomb on them. Okay, here we go.
You asked the defense about ARCA, and it was represented these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812.
Why is she asking where in the transcript? So the lawyers, I think this was on Court TV, who were commenting on this, said the judge could not have forgotten this interaction between herself and Yannetti. So they all understood that she was being called out for letting a fraud go on under her nose. And by letting it happen, she made it happen. A fraud upon the court. So this is why I think that there will be maybe harsher punishment than usual, because Judge Canone has been exposed by this. And now she is pushed to do something, embarrassed in the legal sphere.
In 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed in over a long period of time with requests and deadlines. I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive. Just when I read the materials, and Attorney McLaughlin actually identified them, they didn't respond to our request. So Attorney McLaughlin wrote back, and then we got new material.
50 Shades of Red, the Alan Jackson story. Look at its face. And I've just been watching Peggy O'Keefe through this hearing, twirling her ankle, the ever-present handkerchief clasped in her hand, because she often breaks out in tears in these hearings. She gets it, and she seems to be looking right at the defense through most of this. But look at the beet red Alan Jackson.
Materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information.
It wasn't just the Commonwealth. They lied to the jury. They enacted a fraud upon the court. I mean, obviously, his point is that they couldn't expose. They didn't have the material to expose the ARCA witnesses. Because when it's hidden, and that was the point for not handing it over, to hide it. So you can't bring the receipts to the witness. Oh, you said you weren't being paid? You testified? What is this? Well, there you go. But they know that they couldn't be called out on their fraud because they pretended to the court that they never talked to these witnesses, couldn't talk, were federally barred from talking to them. So if that's true, now they can talk to them because the federal investigation's over. I thought that was pretty obvious to everyone that the federal investigation's over and feds are not coming. No one's being indicted except the only one who's being blamed for this is Karen Reed correctly.
Response, hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic.
So D&T list, so is that direct testimony? Or is that does anyone know what D&T stands for?
Please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the.
So thank you, deposition and testimony. Thank you, Dawn and Mama Gigi. Thank you. And snow remover. Thank you. You all got it. I thought it was direct testimony, but depositions and testimony. Okay.
Luxury to privilege did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins and the notes, this fair-minded, objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter.
Right. I'm going to help you with your case. It's really important to show the jury that it doesn't matter whether I actually examined the vehicle or not. Did you all see Alan Jackson? Like, there's a moment where he's reading these communications between Daniel Wolf and Alan Jackson, and Alan Jackson has it's like a kid throwing down his baseball hat in the middle of a game after being caught cheating. Like, oh, darn it. Caught. Foiled. Did you see it? It was just like a little bit. He was writing, and then he stopped writing and kind of looked up. He looked so annoyed. His fraud is being exposed. And Judge Cannoni's willingness to go along with their fraudulent behavior and let it happen.
In this case.
The date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh, don't tell them. Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times when you asked how many I've been qualified. I missed.
Free Karen readers were all over the place. Well, he did testify to that. So it wasn't hidden from the jury. But that's not the point. I mean, leave it to free Karen readers to not see the forest through the trees. The point is the hiding of the relationship, the hiding of the payment, the misrepresenting your relationship to the jury and to the court and to the judge, all to hide, and so you can sandbag the prosecution. All to hide what you're going to say. And this was done with 3 witnesses in this case.
Misinterpreted the question, my fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925. That's not Trimble. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth.
Unfair, imbalanced, and hidden. I mean, he's destroyed. And Peggy O'Keefe has not moved her eyes from the defense table through this.
Like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess.
So when she comes back, after a long break, he corrects himself and says he got it from the defense. But here we go. Just Judge's response. Judge Canoni's response. Notice her hands shaking.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that
defense and defense counsel, profound effects. They could lose their license. They could get thrown off the case. They could get some kind of smaller sanction.
reason I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared.
Why did she have to give him time to be prepared? What's there to be prepared about? Are you giving him time to concoct some fake story, some other fraud to cover up your first fraud? Excuse me for being skeptical of the defenses. They proved to be the most dishonest bunch. Been calling them out since the beginning of this case. And asking, why haven't they been reported to the bar? They've gone so beyond the rules of their profession through the entire case. And just to show you how the other lawyers are willing to join in, here's a little piece of a news story written about it. And this is where I'm going to end it. Jackson is a California licensed attorney who was given special status known as Pro Hoc Vice to be Karen Reed's lawyer in Massachusetts. Quote, "This is a complicated situation," unquote, Lou said. "It appears that California does not have a requirement that the defense disclose promises, rewards, and inducements to a witness. But that's not what it's about." He lied to the court. It doesn't matter if you have to disclose it or not. He said he did disclose it and said they weren't being paid. If they hadn't been paid, they were expecting to be paid. "I'm not a member of the California bar. We assume," so this is a lawyer talking, "if we assume Mr. Jackson does not know about this Massachusetts requirement, it is immensely helpful to him." So this Lou lawyer is helping him out. Say you didn't know, but it doesn't matter. It's not the point. Technically, he's required to know Massachusetts law, but we have to understand that these are fallible humans trying a homicide case. If Mr. Yannetti does not know about Mr. Jackson's invitation for an engagement letter, retainer request, and possibly a bill, and Mr. Jackson possibly small preparation of the witnesses, he cannot fairly be held responsible. The same analysis holds true if the question is whether they violated a continuing duty to disclose any of this information. They patently lied about it. Do you see how these lawyers are so willing to help out these fraudulent lawyers, other lawyers? And no disclosable information existed at the time of Mr. Yannetti's statement. We don't know the facts, but as an attorney, we do, because Hank Brennan gave us the facts. Some of them. We don't know all of them, but we know some of them. If there are other facts that change it, I don't know how you could change it. We don't know. We all heard them lie to the court. They're on record. We don't know the facts, but as an attorney, discipline matter. It is unfair to penalize fallible lawyers acting in good faith. They never acted in good faith for technical violations. Can you believe this nonsense? Janet Gardner, forgive my last super chat. I typed in a hurry and hit send, not seeing all the typos. Let's all hope Tuesday turns out the way it should. Time to expose the liars and move closer to justice for John. Agreed. Perfectly put. Good way to end this episode. I am off tomorrow, but I will be back Tuesday for at 11 a.m. for the hearing. I'm going to try to put that up now. So, guys, if you want to watch it with me, be watching it on my channel, and back Tuesday night at 6. Thanks so much for listening. And I'll see you all then. Going out with my song about Karen Reed. Have a great night, everybody. Happy birthday, Grandma. Miss you.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mom. My innocence fraud campaign is my biggest hit yet. I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mark. My innocence fraud campaign is my biggest hit yet. John,